Good morning or good afternoon, depending on what part of the United States or around the world, wherever you're tuning in from. I'm just going to wait for about a minute for people to tune in, and then I will get started. Let me try and adjust this in the meantime. I hope everybody's having a wonderful summer thus far. I guess I will get started. My name is Ayesha Chidolue. I am a trademark attorney here in Orlando, Florida. I represent clients all over the United States and internationally as it relates to trademark matters. Our contact info here is 407-995-6567. You can also check out my website, www.chidoluelaw.com. So if you've never tuned in before, welcome. This is Lipsticks and Trademarks. I do a Facebook Live video every Friday at 12 p.m. Eastern Time where I talk about what lipstick I'm wearing and something interested in trademark. I welcome you to ask questions and, I'll be more than happy to answer the questions as long as it's within my capacity. So first things first, today I am wearing, it's called MAC Retro Matte Tailored to Tease. So it's kind of like a purple pinkish lip gloss. Well, not lip gloss, it's a matte lipstick, so it dries on matte. As I'm sure you see, most of the time I wear matte lipstick because, I spend my day talking to people a lot. So I just don't want to have to worry about, my lipstick being on my teeth or smudging if, I'm having lunch with a networking partner or whatever. But anyway, lipstick out of the way. So today in Trademarks, I want to talk about what a principal register is versus a supplemental register. I know most of you are like, what is that? So typically, when you get a federal trademark, you can either be registered on one of two registers. One is the principal register and one is the supplemental register. So the principal register is where names that are distinct are typically registered, and that gives you the highest form of protection. For example, when you have names that don't ordinarily make sense in the English dictionary, examples can be like Xerox, Exxon, Kodak. Before those companies came into existence, those names didn't exist. Those names basically don't make sense. And so they're distinct for that product. And then another kind of mark that gets registered on the principal register are names that are arbitrary. So they're not necessarily distinct, like names like Apple. So, Apple makes electronics, makes software. So something like Apple, it's an arbitrary name for a software or, a computer-based company, but because it doesn't relate to an actual Apple, then it can be registered on the principal register. Same thing was, I'm trying to think of another random name, like, I can't think off the top of my head right now, but so that gives you an example. So names basically that are arbitrary, but it doesn't describe the product because, if you hear Apple, you're not going to think, computers, you're going to think Apple Farm or something. Now, if you're an Apple Farm and you named yourself Apple, that would be considered descriptive, or generic. So, so typically when your name is distinct in that capacity, you are allowed to get on the principal register. But then there are some times when, you have names that you think are unique, but they would be considered descriptive or generic. So for instance, I'm trying to think of an example. Okay, yeah, so I have an example actually. So for instance, many of you, if you've ever worked for an employer that offers healthcare benefits, you probably were offered the option of a healthcare savings plan, right? So, or the short form being HSA. So when HSA applied to register their mark, the issue was that the mark is too descriptive because healthcare savings plan is exactly what it is. Sorry, healthcare savings account is exactly what it says it is. So that's an example of a descriptive mark. So, what typically happens when your mark is descriptive is that, they would usually recommend, that's the trademark examiners would usually recommend that you put your mark on the supplemental register until it has the ability to acquire distinctiveness. And on average, it typically takes about 5 years. So, HSA was able to register their mark on the principal register on the basis of acquiring distinctiveness because, they've been doing this for, a couple of, for a long time, basically longer than 5 years. So, in situations like that, that's what happens. So really, my advice is, if you ever get back from the examiner saying that, your mark is descriptive, sometimes you can get descriptive because your mark basically says exactly what you do. Sometimes you can also get descriptive based on if your business is your surname. So sometimes there's merely descriptive on the basis of surname. So surname meaning last name. So if your last name is just what it is, sometimes you can get descriptive depending on what you're registering, whether it's just the name as it is, as, a word mark, or whether you're registering the name as part of like a elaborate logo. Obviously you have a stronger chance of it being distinct if it's part of a logo, but if it's just the name you're registering, they're probably going to push you, as merely descriptive surname to the supplemental register. So what happens, when you're moved to the supplemental register? So real quick, like I said, with the principal register, you have the maximum protection, from a federal trademark perspective. Your mark between the 5 to 6 year mark, once you file your section 15, your mark is incontestable. Nobody else can contest your mark at that point. You can basically have your name registered with the U.S. Custom and Borders so that it can prevent people from importing goods related to your mark. And then, of course, there's a presumption of you as the owner of the mark. So the cons of getting registered on the supplemental register is, of course, you cannot register it with the border, so sometimes, some people or some countries may bring in items that are in conflict of your mark. Right? And then the other thing is there's no presumption of ownership. Excuse me. You're going to have to prove that you do own that mark. But so those are like two of the main disadvantages really of being on the supplemental register. But I really want to talk about the advantages because, what I'm trying to communicate here is that all hope is not lost if they reject your mark from going on the principal register. Because once you get on the supplemental register, one of the benefits is that, one, you still get the registration. So you get the R symbol registration, and you have protection against confusingly similar marks. So if you're in a supplemental register, you're still going to appear when a search is done, whether it's a knockout search or a comprehensive search on the USPTO. So essentially it still puts people on notice that, somebody else has this trademark, and so they can't say they didn't know that you have the trademark. The other benefit of it is that you can sue for infringement in federal court, if, somebody infringed on your mark. And then the last and the best news is that your mark, even though they register your mark as a descriptive mark, you still have the ability to acquire distinctiveness over time. So if your mark, after like a couple of years, everybody knows you, you're the only one in that brand, or like you're the force to be reckoned with in that brand, you can apply, for the principal register and move to a principal register on the basis of the fact that your mark has been in business for 5 years and you have acquired distinctiveness of that mark, or you dominate that market. So really, it's not the end of the world, being on the supplemental register, but I just wanted to give you your options because it's better than not being able to be registered at all, because again, you're still going to be registered. And so the other thing is that for your mark to be considered and registered for the supplemental register, your mark needs to be in actual use. So you cannot file an intent to use mark. And what is an intent to use? A mark that you haven't started using, but you're just filing it in anticipation of using it. And the only way for you to get on the supplemental register is for you to actually be using your mark. So, I hope this video has been helpful. As always, I'm an attorney, but not your attorney. I love to do these shows to educate, entrepreneurs and people who want to protect their intellectual property. Personally, I think that your intellectual property is one of the greatest investments that you can make in your business as a small business owner, because it gives you an instant asset in your business, and it gives you leverage when you have bigger corporations trying to bully you. So I hope you'll share this video with others, and definitely please smash the like button, the love button, and I would love it if you could share this. All right, have a great weekend. Thanks. Bye-bye.